First of all, Alvin and I aren't going to give advice because that wouldn't be right, but we just want to share a few of the things that we learned not to do and to do in the courtroom and around the community once the ministry or child protection organization has become involved in your life. So first of all, don't underestimate the Ministry of Children and Families. Don't underestimate where they get their information from. You know, they'll take a piece of information from a neighbor, you know, that's
barely knows you.
Barely knows you and has the story all wrong, and they'll take that and twist it even more, and you'll hear a totally astounding story about yourself in the courtroom.
Yeah, and they won't go looking for people that will back you up or provide any good information.
They only look for the people and listen to the people that are going to make their case stronger. Well, that's what they did in our case.
And in many other cases that we've heard about in the past.
So the number one thing that we learned was to realize who you're up against, a law firm that represents a government agency.
And they're out to win, and they will be ruthless.
And they've seen, from what I've seen in the courtroom, and I've sat through many hearings, and I've spent many days sitting in the courtroom in the last 4.5 years. The Ministry of Children and Families has probably come across every possible scenario, including yours. So they've represented themselves against those situations before, and they know what they're doing, obviously.
And of course, you feel when you first go in there that that there could be no possible reason why they would take your children and keep your children away from you. Because
you might even sign consents for certain things, believing that you're a good mom or a good dad, you just have some problems, but you know, your child gets all the love and nurturing and nutrition and affection that it needs, but that's not enough.
That's not enough. Not for them. Once they've dug in their heels, you can be assured that you're going to be made out to be a horrible, horrible person.
And another problem that we've encountered with other people's stories is that the judge that was residing over their case had actually been a lawyer for a law firm that represented the child protection agency in the past.
Yeah, so
which
you don't
creates
a total bias.
We've seen situations where the judge totally doesn't let any of your subpoenas in. None of your witnesses get to speak, only their witnesses get to speak, and you might not even get the opportunity to
fully cross-examine them. Or even finish cross-examine them, because the judge will have shut you down. And this is so typical of the tactics that they pull in court. And the thing is that you go in thinking that you're going to make your point and your children are going to come back.
But the information that the judge has been given by the Ministry of Children and Families may not be accurate, and the judge makes their decision based on the information that they've received.
Inaccurate.
And you have very little time in the courtroom to ever defend yourself, if you even get a protection hearing. Yeah. Which you should always, if the ministry is involved with you, read through the CFCSA and find out the difference between a presentation hearing, a protection hearing, a case conference. Know what types of orders can come out of each different situation, what the judge is allowed to do on those occasions.
Yeah, there was a time we had the opportunity to put 2 social workers on the stands, and there was a lot of information that had been omitted, so the judge never actually was permitted to see this information. And after cross-examining these 2 social workers, we brought out the fact that they knew that the children were being abused by the people that they had placed them in their care. And the judge even questioned them on why they wouldn't put 2 and 2 together. And so it was made glaringly obvious that these children were still being abused in the ministry's care, and the ministry wasn't...
And the children were left in that position.
In that position.
It's very difficult to get any change made through court because the process is so long and so twisted I mean, you're supposed to get, within 7 days, there should be a presentation hearing after the child's been apprehended. Within 45 days, there should be a protection hearing. But now the Ministry of Children and Families has you know, they go into the courtroom and they say, we'd like to have a case conference first. And legally, they have the right to say that, because if the parents and the Ministry of Children and Families don't agree on whether or not there should be a protection hearing, it goes to a case conference, which is ridiculous because parents rarely ever agree with having their children in the care of the ministry. But, so the protection hearing that should occur within 45 days of your presentation hearing may not occur for 3 months, 6 months, whatever, whenever, or it may not occur at all.
And those are legal tactics.
That protection hearing is supposed to be, you know, done in a timely manner so that you can defend yourself or make it known to the court that the child shouldn't have been apprehended. But if you don't get that opportunity, the child will have been in care so long by the time you get there that the judge will say, well, let's just leave the child status quo.
Yeah.
You know?
Yeah, they seem to be settling in nicely, this, that, and everything, because that's who's writing that report is the ministry. You know, the children.
But this is another reason why it's very important. I have to add right now that never, you know, we made it a point never to miss a court date ever, because there was one time we showed up at the courthouse just to do something else, and our name was on the frickin' docket. And we were like, what the hell? It was a good thing we showed up, because they were trying to change a date of one of our hearings without us being present to, you know, say, no, that's not what we want to have happen.
Yeah, and we just went in to file
So,
something.
always make sure, you know, even if your lawyer, oh, no, you don't have to show up. You know, our lawyer said that to us before, you know, and we made sure we were there every time. And you also need to take every opportunity that you might, you know, even if it's only a small possibility that you'll get to say something to the judge. You need to get those points out. You need to make sure that the judge is aware of what the situation really is. You know, don't walk away from the courtroom allowing the judge to be left under a false impression. And if you don't get it all out in that court date, maybe you'll get some out later. But that's the other point that's very important to make, is always be composed. No matter how depressed you are over losing your child, no matter how much you want to cry, no matter how much you can't face that social worker that's sitting in the, you know, bench next to you, do it. Be composed. Have a smile on your face. Let the judge see you looking good. You know, don't show the judge that you are what the ministry has said you are. Don't let that happen. Always look composed. And that's where community comes in. Always look composed out in the community, because it will come back to the courtroom. Always, you know, don't go walking around drunk because it's Christmas Eve. Don't bother doing that. Not this year, because it'll come back on you in the courtroom.